I think the first case is a MOA, and we will get started with that right away. It's In Re Piland Minors.
Kayla Crino for petitioner. May it please the court. Though this application deals with two questions, this case is unavoidably about competing interests. The state's interest in keeping children alive and safe from harm, and whether a parent who knowingly and intentionally withholds life-saving emergency medical treatment for a child, ultimately causing that child's death, has a defense to adjudication based on the language of MCL 722.634. Petitioner has raised three arguments in answering the court's first question. First, MCL 722.634 contains a limiting clause. That limiting clause is the phrase, "for that reason alone." The phrase "for that reason alone" means that parental actions are only protected for the limited reason articulated in the statute. This can only mean one thing: that parents can still be negligent and ultimately adjudicated for reasons other than the limited reasons contained in that statute. Second, the Court of Appeals' opinion was entirely too broad. The Court of Appeals ordered the instruction without regard to the court's authority and duty to decide whether the instruction is factually applicable or whether it accurately states the law. Third, the people are prepared to litigate the issue of whether respondents were legitimately practicing their religious beliefs. However, it is our position this is an absolutely absurd inquiry to put before a jury or before a court. As to the definitions of refuse and neglect, they do not mean the same thing. They are both included in MCL 712A.2B1. They are separated by the word "or." Neglect is defined, and it is defined in a very specific way that does not include every type of failure. It includes failures that are based on negligent treatment and failures that ultimately cause harm based on that negligent treatment. The solution proposed by respondents leads to a result that would dramatically increase the scope of the exemption by including virtually any type of failure with any type of consequence, and that is simply not what this statute says. And there are three significant actions that we're asking the court to consider taking in resolving this conflict. The first is to examine whether an instruction based on the exemption does violate the Establishment Clause by mandating excessive entanglement. In the event that the court finds that it does not, petitioner is asking that the court provide guidance as to what some of these ambiguous terms within the statute mean. What does the clause "for that reason alone" mean? What does the clause how does refuse and neglect interact with this statute? And third, in the event that the court is not inclined to provide guidance on either the terms refuse and neglect or the limiting clause contained in the statute, the petitioner is asking that the court, at a minimum, remand this to the trial court so that they can examine what these terms mean and make a decision, as is their duty, regarding whether a jury instruction is applicable to a trial that the court is going to hear under the court rule. As to the argument regarding the limiting clause "for that reason alone," the petitioner wants to be very clear with this court. We are not asking that the statute be changed or added or limited in any fashion. We are asking that the court look at this statute and apply its plain language, the clause "for that reason alone." Jurisdiction in this case is not being sought because the respondents here were legitimately practicing their religion. Jurisdiction is being sought in this case because there was a gravely ill child who was in need of emergency medical treatment. Rather than provide that emergency medical treatment for that child, respondents in this case watched that child get worse over a period of days. The evidence will show that they watched her suffer, that they watched her skin turn yellow, that they watched her eyes turn orange, that they watched her slip, and they did absolutely nothing. And ultimately, because of that decision to do absolutely nothing, the child died. This is child abuse in the first degree. This is not mere negligence. This is not negligent treatment. This is knowingly and intentionally causing physical harm to a child. And that is ultimately why jurisdiction is being sought in this case. And that is why Michigan's personal belief exemption is not applicable to respondents. And this is not a new or novel or unique idea. This is, in fact, the conclusion that every single court that has examined this issue has arrived at.
Counsel, isn't it the case that a lot of the other courts that have examined it did not have the same statutory language? Michigan, for some reason, decided to basically adopt word for word the Department of Health, Education, and Welfare's CFR language regarding the exemption, right? The legislature could have written in could have tailored it a little bit differently, but it seems like the legislature just took the words of the CFR and slapped them into the statute, and even though they're no longer required, left them that way. They haven't amended it. So, I mean, the other courts have interpreted different provisions.
That is correct somewhat, but I would direct the court's attention to footnote 104 from the petitioner's initial brief. That wasn't an accident. That was based on our research into every single statute that contains a limiting clause that's similar to Michigan. And while there is some variation amongst those, and I pointed that out directly as to each one, the majority of the statutes do contain that same for that reason alone clause, like what we have here in Michigan. And in addition to that, the courts that have examined this question, while they might have slightly different terminology as to different things, such as what is required for adjudication and what is the exact language of their exemption, what they all have is the same general framework, and that's something that has to be proven in order for there to be adjudication, and then followed by that, an examination of whether the reason for seeking adjudication is a reason other than what's articulated in their exemption. So the reasoning, it's very salient when we look at Michigan's framework. The other thing I would indicate for the court that was not an accident is we did not simply choose cases that were favorable for this court to consider when we looked at other jurisdictions. We, in fact, brought this court every single case that has examined the meaning of a limiting clause, like the one that we have here in Michigan. So there isn't another case that we can point to and say, well, they looked at a limiting clause and they said that what that means is we'll just ignore it. We'll pretend that it's not there, and we'll say that the statute protects everything. The limiting clauses are interpreted universally the way that they're intended to be interpreted, and that's what we're asking this court to do here. Colorado, California, Wisconsin, and Oklahoma, these are the courts that have looked at this issue, and they've all uniformly found exactly what we're asking this court to find here. I would especially indicate I felt Colorado in Ray DLE was an especially salient case for the court, because that case took a look at whether the analysis changes if you have a child who's not ultimately harmed, and that's what's really significant here. We have a child who died because of their parents' choices. And so if you look at that Colorado case, they examine it under two different factual scenarios. The first scenario being a parent who makes a medical decision based on their religious beliefs, and the child is not harmed, and everybody gets to go home, and that's fine. And then what happened later, unfortunately for that child, the court had to wait until there was irreversible harm before saying, no, when your decisions harm a child in this way, you're not entitled to that protection based on the limiting language contained in their statute as well. So
Well, you say if the child recovers or has done no harm, everybody goes home happily. I understand that, and I think everyone wishes that had been what had occurred here. But the statute does provide protections of some sort to parents who do certain things with regard to their children when those things that are done have some foundation in the religious beliefs of the parents, right?
That is...
What is it specifically What specifically is being protected here, and under what types of circumstances would those protections be applicable? When things, I'm sorry to
please.
interrupt you, but specifically, when do those protections kick in when everybody can't go home happily?
Well, the first and most important thing is that that limiting clause has to be applied. So if we're talking about declining a specified medical treatment, that is not a reason by itself to seek adjudication. So when we look at that limiting clause, that's how it has to be applied. It doesn't say that if the child dies, you're entitled to protection, if the child is subject to irreversible harm or some other type of harm, that child is then not protected. And I assume that the court's question may go somewhat to the second portion of MCL 722.634, indicating that the state can still take some type of action if the child is in need of medical treatment. And interestingly, Oklahoma, one of the cases that we directed the court's attention to, has the same type of clause, and yet they went through the same type of analysis that I'm asking the court to adopt here. And that's outlined in NRA DR, the 2001.
Please summarize for me again. It's a complicated case. When is the parent protected when they undertake some action or inaction with regard to their child predicated upon their religious or motivated by their religious beliefs?
It has to be by the language of the exemption itself and the very limited.
Of course it does. We all agree on that.
The very limited purpose that it's designed to protect, Your Honor, and that is from a parent being considered a negligent parent. So then we can look at what the definition of neglect is within the Child Protection Code, and summarized and eliminating portions of it that are not pertinent to the factual scenario we have here. We're talking about harm caused by a parent due to negligent treatment. Negligent treatment. And that brings us to the court's second question that we're here to address. It is denying a child who needs emergency medical treatment in order to live, and then watching that child die, merely negligent treatment, which is what this limited civil exemption is designed to protect. So I would say, in general, if you have a factual scenario where the parent's actions could be described as mere negligent treatment, which is defined for us in the Child Protection Code, assuming the court is not inclined to address the Establishment Clause problem, which we think that there is here.
Negligent treatment does not encompass a refusal to treat. Is that your proposition?
My proposition is that there are different types of failures. And
well, give me a real-world example of where a parent might, on the basis of their religious precepts, be protected by the language of this provision.
Okay, so an example of where that might apply, and arguably here, because this is not a vaccine case, and that's also in and of itself a very hot button issue, but arguably I would say that declining to provide your child with a vaccine, if perhaps your child then got sick from whatever that vaccine was designed to protect, is that intentionally harming your child? Is that reckless conduct? Is that child abuse in the first degree? I would say certainly not. But that might arguably be negligent treatment. And that would be an example.
Because I have a question, though. I mean, I was going to ask you about the vaccine issue as it pertains to this case. And help me with this, though. I guess what we're grappling with is when you refuse to do something, I guess what you're trying to explain to us is that how many, what the Court of Appeals was saying, how am I to distinguish this between the refusal and negligence? If I make a choice to refuse something, is that in of itself negligent? If I make a decision and I say, I'm going to refuse to get a vaccine, or I'm going to refuse to take certain medications, where I'm having trouble is the refusal, if it's based on a choice and I'm confused as to how I make my choice. We all make choices, and at what point does the refusal in of itself become negligent?
So I think that has to be a fact question.
Okay.
So negligence is defined, and as the court is aware, refusal is not defined in the Child Protection Code. So we can, of course, look at common definitions of refusal, and if we're willing to make that jump that refusal requires a little bit more intention, a little bit more information, being informed of the risk, and then making a decision based on that. I think that that's reasonable, although it's certainly not the only interpretation that the court could accept here.
But is getting medical attention an action or is it an omission? Like if I don't get medical attention, am I refusing it by not going to get it, or am I omitting to do it?
Every refusal is also associated with a direct action.
I see, okay.
So here, yes, we have an absolute refusal to provide life-saving emergency medical treatment, but in addition to that, we have actions that required making the choice to stay home, making the choice to not call for help, making the choice to isolate the child from the people who wanted to provide her with life-saving medical treatment.
Was there an actual written instruction presented to the court, this is what we want, or was it simply, we want you to read the statute to the jury?
My understanding is that contemporaneously there was discussion amongst the parties about this statute, and what was presented for the trial court to consider was a jury instruction based on the first portion of the statute, which respondents of course wanted and petitioner did not want, and they both filed motions at the same time regarding that. Unfortunately, those motions focused on whether the statute was applicable at all to child protection proceedings. It unfortunately did not address some of the issues that we're here discussing today.
So the Court of Appeals said there must be an instruction.
Yes.
But was there ever an instruction that was put on the table, this is what we're arguing about?
My understanding is what was requested was an instruction based on the first clause of the statute. So they didn't propose to tweak it or change it in any way. It was simply a requested instruction based on the first portion of the statute, which the trial court in their discretion declined to give.
Okay.
Thank you very much, counsel.
Thank you.
May it please the court, Vivek Sankran on behalf of the appellees in this matter. Happy to waive my free fire period and take questions this court may have at any point. I think the fundamental tension in this case is that Michigan, unlike several other jurisdictions, has chosen to enact probably the broadest type of statutory exemption that can be imagined. Our statute has made clear that a parent can refuse to provide specified medical treatment to a child based on religious beliefs, and if they do so, that is not considered negligent treatment under our juvenile code, child protective code. Other states, and we submitted this in our brief, have made different legislative choices. Other states have had has language that's somewhat similar to ours, but then have exceptions to the exemption. So, for example, just to give this court an idea of the legislative choices that could have been made in Michigan, California has an exception to the exemption where there's serious physical harm or illness possible to a child. Oklahoma has an exception when there's permanent physical damage that could occur to the child. Oklahoma, to protect the child's health or welfare, so a broader exception to the exemption. And so from our perspective, this case boils down to a choice that the legislature had made. And I think, Justice Markman, your question about what protections under the interpretation given by the appellants, what protections does that give individuals who practice religious beliefs? I can't think of an example of where the statute would ever apply should you accept the other side's argument.
Didn't she provide an example in terms of the refusal to vaccinate one's child?
I don't think that's an example, because I don't actually see a fundamental difference. If something wrong happens to that child as a result of the failure to vaccinate, it's the same case as we have in this situation as far as we're concerned. The idea, and this is something that I think is really important to spend some time on, about thinking about harm and how it relates to a finding of neglect under our juvenile code. We don't automatically assume jurisdiction of a child based simply because a child has been harmed. Best example I can give, kids in a car accident, something happens to that child. We don't then file a jurisdictional petition because there's been no parental conduct that we can ascribe was abusive or neglectful to the child. And so you need the nexus between the negligent conduct and what has happened to the child. The problem in this situation is we have a legislature who has stated in a statute that this type of refusal is not negligent treatment. So there's nothing in the statute that says except unless something sort of bad happens to the child. And so simply pointing out that, well, we're going to protect this parental choice, but then almost what they're doing is creating a strict liability type of situation. But if something bad happens to the child, even though we have said as a state that individuals who practice their religion can choose not to provide medical treatment based on their religious beliefs, what the appellants are asking this court to do is read in language creating the exception that other states have done.
You would agree, though, the free exercise clause is not without limitations in this area, correct?
Correct. We're not making a constitutional argument in this case.
Okay. The law is you get a special instruction only if the instruction properly informs the jury of the applicable law. It
Correct.
seems to me what we're looking at here is an argument whether the jury should be read the statute. And isn't there much more here? I find some appeal in the concurrence dissent. Shouldn't the jury be instructed, you've heard evidence of religious practice, you must find that they legitimately were practicing their religion, or that there are limitations to what can be done? Shouldn't all this fact-finding be done by the jury? And since we don't even know what's been presented, shouldn't we say an instruction may be applicable, it must state completely what the applicable law is, and the trial court should make that determination based on the evidence presented on remand?
I don't disagree with the notion that the jury should be instructed pursuant to the provisions of the statute about whether someone's legitimately practicing. That's all fact-finding that's in the province of the jury. I think the issue for this court to wrestle with, though, is what are the appellants are proposing a much broader set of limitations as to what this actual statute means. And that, as to whether there are, essentially what they're asking the court to do is draw a broad exception that if a kid is harmed as a result of the choice that a parent makes, then this statute doesn't apply.
Counsel, are there any limitations?
Under this wording of the statute, no, unless, and this is an important exception, the phrase "for that reason alone" means that if there's another reason for a court to invoke, another reason to find that there's neglect or abuse in the case, separate and apart from the refusal to provide medical care, that could certainly be. So let's say a parent physically abused a child and also chose to not provide medical treatment. Well, that would provide an independent reason for the court to assume jurisdiction of a case. But there is nothing in the plain language of the statute.
Could I argue that that's a religious tenet, that corporal punishment is based on a religious belief as it pertains to discipline? Would that then serve as an exception?
No, because the statute is specifically limited to medical treatment.
I see.
And so there's no, that would be, so.
No, I understand.
Correct. And so what really exists in this case is if the department wants a different statutory framework, certainly they could ask the legislature to change the statute. And in fact, there have been times, since the enactment of the statute that folks have tried to amend it, repeal it. I think coincidentally, the trial court judge in this case, as a legislator, tried to repeal this specific provision of the statute back in 1997, and it didn't go anywhere. And so I think that this is a legislative judgment in the end. I do want to spend just a quick minute talking about the refusal neglect distinction, since this court raised it. I think we have two responses to that. First is under our statutory definition of neglect. Neglect is incredibly broad. It's defined to include any failure, not just an unintentional failure, to provide medical treatment. Just to sort of frame the issue for the court, at the time the Juvenile Code was passed, back in 1944, there were no statutory definitions of neglect in the code. And so if you open up a dictionary, there clearly exists a difference between neglect and refusal. Neglect is seen much more as passive, right? Something that didn't require an affirmative act, whereas refusal, under Black's Law Dictionary, implies the positive denial of a command. Makes sense. It's kind of the common way that we use those terms. In 1982, the legislature included a statutory definition of neglect to include any failure to provide medical care or clothing or financial support. And so it's a much broader definition now of neglect. At the trial court level, we don't make these sort of distinctions between neglect cases and refusal cases. Everything generally is referred to as a neglect case. The other thing that I'd like the court to consider about the distinction is if there is a distinction, I don't understand how this exemption could not apply in refusal cases, because by the very nature of the exemption, that word specified in the exemption suggests that the exemption only applies if a parent chooses not to provide specified medical treatment to a child. So if we think about the traditional definitions of neglect, which is really, I forgot to do something, wasn't actively involved in it, the word specified suggests that this exemption applies when someone has told you something, like this case, and you choose not to do it. And so again, I can't think of a fact pattern where this statute would apply, where it wouldn't come under the definition of refusal as well.
Counsel, I agree with you that the definition, the now applicable definition of neglect is a pretty broad one and arguably encompasses most aspects of refusal. If we were, however, to look at the more traditional understanding of neglect, one that not only encompassed the concept of passivity, as you've suggested, but also the concept of inadvertence, it's pretty hard to understand how somebody on the basis of their religious faith could, under very many circumstances, if any, in the act of negligence, harm the child, according to on the basis of their religious values.
Yeah, I agree. It's hard for me to understand how, under that traditional definition of neglect or negligence, how this statute would even apply, because this statute really does require some sort of affirmative act and decision not to do something in a way that we don't think of as traditional neglect. So for those reasons, unless there are further questions.
I have one. Are there? It's an interesting case because we haven't yet heard the proofs, so we don't know anything about exactly what your clients might testify about what their religious practices were, and does any of that matter? I mean, can any parent take the stand and say, I have a religion, it's just my personal religion, and the religion requires me not to get any medical care for my kids? Does it matter at all what the testimony is? Is that a question that makes sense?
So I don't think it matters for the instruction then that the court would be required to give. I do think it matters to what Justice Zara said about whether the jury then can decide whether or not that's a legitimate, they're legitimately practicing that belief. So I think for me that's where it matters, as opposed to whether the instruction should be given. Obviously the trial court has a responsibility to see if there's some quantum of evidence to justify this instruction. But this case isn't about, the fundamental disagreement between the appellant and us in this case, it doesn't revolve around that. It really revolves around when this exception should even apply when a child is harmed. That really is the fundamental tension in this case. And our position is that the statute is so broadly worded that it applies regardless.
So you don't think the statute effectively directs a verdict? Do you think a jury in some cases might still, even hearing this instruction, decide that the parents can't, that it doesn't really help them, that they're, for whatever the facts were,
Correct.
That they really can't satisfy that?
Correct. I mean, there's been sort of in the briefing, evidence perhaps they weren't really doing this for religion, whatever that might be. None of those issues have been litigated yet, but a jury could, after getting instructed, decide that this instruction doesn't apply. That's not a basis in this case.
Should the jury be instructed that the parent's right to practice their religion is not without limitation, and that at some point when it's evident that harm is coming to their child, that they no longer have that right?
Under this statute, I don't think that's consistent with the law. I think this statute doesn't, this is where, if they were in California.
It's really a constitutional question at that point, that their right to freely exercise their religion does not extend that far. Wouldn't that be something that the jury can consider factually?
If the court wanted to instruct them on the First Amendment, certainly they could. We're not arguing that the First Amendment gave our clients the right to do this.
Well, I understand, but a special jury instruction is only to be given when it fully and completely instructs on the law. Yeah. So wouldn't that also be something See, that's why it's hard for me. I don't know what instruction you were arguing over. All I know is you're arguing over the statute says I should get an instruction. And so I'm at a loss. I'd like to look at an instruction and say, well, this is an incomplete instruction or an adequate instruction. There's not even an instruction to look at here.
So I think my one confusion, Justice Zara, is just at this juncture, our clients are not arguing that the Constitution protected their ability to do this. It is purely about the statute. So regardless of whether or not there's a limitation, which the case law is, in First Amendment jurisprudence, there's a limitation. But that's.
I think Justice Zara might be suggesting that the department has a constitutional right to have the instruction include some extra language.
If we're going to have an instruction, shouldn't it be complete? Shouldn't they argue?
Just trying to
Yeah,
frame the,
right, I agree
because
with
I
you.
don't think if the parents aren't arguing it, does the department have a constitutional right to have more?
Perhaps, so the jury would find that there was no First Amendment right, but the statute still applies, right? So there's still a statutory exemption. The First Amendment limitation is different than any limitation set in the statute, which is, it's a very broad statute that's different from what the First Amendment jurisprudence is.
You know, I understand why you would reject the idea that there's much of a constitutional component to this controversy, but in a sense, this really is kind of a free exercise type protection for the parents of the child. And I don't know why in the long term the Chief Justice isn't correct that the kind of constitutional questions that have arisen in the free exercise context, the Smith versus Sherbert debate, and whether we're going to have 200 million different conceptions of religion, expressed by parents around the country, aren't eventually going to come to the front of this case. I mean, in all free exercise cases, you have all these related questions. What's the sincerity of the view of the parents? Are they expressing a personal religion or some, more organized faith? If their arguments are on the basis of some more organized religion, what are the tenets of that religion? How are they expressed? Are they well understood and comprehended by the parents in this case? All those constitutional issues, I think, may well be inevitable, don't you?
They may well be. And we have very little case law in Michigan looking at this provision in any sort of way. So I would not be surprised if both of those questions make their way, as this case unfolds, but also in a policy debate.
So how do we skirt the constitutional issues in resolving the application of this statutory protection to parents?
Because I think at this juncture, all that's before this court is whether or not this specific statutory provision should have been, the jury should have learned about it. Our clients are not, again, invoking all of those protections. I don't think that this court needs to, it would be one thing if we were arguing that the First Amendment applied in this case, the court would have to wrestle with these issues. Here, I think a lot of those questions you raised, Justice Markman, are fact-finding questions for the jury about whether the parents were legitimately practicing their beliefs.
So the jury's going to actually undertake a quasi-theological inquiry into the views of the parents.
Exemption cases are not uncommon in other contexts.
I understand.
And so this is nothing that the jury, juries and judges haven't done in other contexts. The draft exemptions, vaccine exemptions, many things historically, this has happened.
Given the lack of any presentation of proofs, was it really appropriate for the Court of Appeals to say they must give an instruction as opposed to if the evidence supports an instruction should be given?
That would be fine. I mean, I don't disagree with that as an alternate sort of ruling, which is if the evidence, if there's enough evidence to invoke the religious exemption, after hearing the testimony, if my clients stated that they took the actions they did because of their religion, then it would invoke the instruction. I think that my reading of the Court of Appeals is they were trying to craft the parameters so that this case just wouldn't come back after a jury trial with the same exact issue before the court, which is one of, instructing the court, the lower court, that this is what this provision means. That's how I read the opinion. All right, thank you.
Very much. The case will be submitted. Nice tie.